Very good evening, all the participants. Let us start from Supreme Court today. So the first case is Innovative Industries. I hope my screen is visible to you.
Yes, sir.
So in Innovative, can anybody tell what happened actually? Has anybody read this case?
Yes, sir.
Yes, please.
Yeah,
So what happened actually?
the petition under section 7, 8, and 9 was challenged, and there were certain law points on which dispute.
Actually, it was
Sorry. This was challenged on the basis of the repugnancy of the Bombay.
Yes.
Maharashtra Act, which says there is a moratorium applied in that particular act also, and which says under that moratorium, the moratorium under IBC cannot prevail.
Yes, actually, this was the first application under IBC.
Yes.
So, and some peculiar features were there. This appeal was filed by the erstwhile directors who do not have any role.
Right.
So, this appeal was filed by the past directors on behalf of the company. So, the first question which arose was whether this appeal is maintainable. So, Supreme Court said this is not maintainable, but because this is the first application that is moved, and so we want to deliver a detailed judgment. So basically they said that, okay, we are entertaining this appeal, but it should not be taken as a precedent. So for the time being, they ignored this lapse. This was the first point. Second is, it was this company, Innovative Industries Limited, was based in Maharashtra. And in Maharashtra, there is a Maharashtra Relief Undertakings Act, which basically applies to sick industries. So whenever any industry gets sick under Maharashtra Relief Undertakings Act, so in order to ensure that there is no loss of employment, because if a unit is closed, then a lot of people will be rendered unemployed. So they say to alleviate the stress of such companies, what Maharashtra Relief Undertaking says is that there will be a moratorium, that the payments may be deferred. So this is it is basically a labor welfare legislation. And that Maharashtra Relief Undertakings Act, that contains a non-obstante clause, which says notwithstanding anything to the contrary contained in any other act. But it is basically a state legislation. Now, there is a non-obstante clause in IBC also, section 238. So, the first thing arose that whether if there is any repugnancy between two laws, then which one will prevail? And as per the rules of interpretation of statutes, basically, first of all, there is a rule of harmonious construction, that whenever two laws are there and there is any inconsistency, so they will try to work out a situation in which both the laws can stand in their respective fields. This is the first thing. Like if you see education laws, so education is a state subject, but policies can be made by the central government also. So normally, state is given precedence in certain matters. Similarly, there are certain laws which are made by the central government. And as you know, there is a union list, state list, and concurrent list, according to which laws are made. And this doctrine of repugnancy says that whenever there is any inconsistency between two laws, then first of all, we will see which one is the later law. So the later law will prevail. This is the first thing. Second situation is that if there is a central law and a state law, then central law will prevail. So these are some of the principles of interpretation of statutes which were applied in this case also. And they said that IBC will prevail. IBC being central law and being a later law, it will prevail. Regarding this fact of the appeal being filed by erstwhile directors, that was ignored because it was the first application under IBC. So repugnancy means direct collusion with each other, reaching a situation where it is impossible to obey the one without disobeying the other. Okay. So then said that they refer to list also that it Maharashtra Act is referable to entry 23, and this code is given in entry number 9, list number 2 in the 7th schedule. So Supreme Court said that Maharashtra Relief Undertakings Act cannot stand in the ways of the IBC. Okay. So Supreme Court was of the view that the tribunal was correct in appreciating that there would be repugnancy between the provisions of the two enactments. So this was basically the facts. So issues in paper, whether directors of suspended board can file the appeal. Answer is no. But in this case, Supreme Court allowed it being the first application. Second is whether there is any repugnancy between Maharashtra Relief Undertakings Act and IBC. Yes. And then IBC will prevail. Then they gave a detailed judgment. Just a minute. Okay. Now, second, Mobilox innovation. Mobilox innovation में हुआ क्या था actually? Kirusa Software was actually awarded a contract by Mobilox Innovations. Mobilox was innovation that was actually engaged by Star TV. So there was a program which was coming on Star TV, Nach Baliye, and they engaged, Mobilox engaged Kirusa Software. But there was a non-disclosure agreement between the two parties, and Mobilox instructed them not to share this detail on their website. But Kirusa Software displayed it on their website that they were working for Star TV. So this was basically the dispute between the two parties. And when Kirusa raised the bill, Mobilox refused to pay, saying that they have violated the non-disclosure agreement. So this was the basic issue. So the issue involved was whether the breach of this non-disclosure agreement amounts to a dispute. This was the first point which we have to see. And second point was whether adjudicating authority must reject application under section 952D if notice of dispute has been received by operational creditor or there is a record of dispute in the information utility. So they said because a dispute exists, so there need not always be a suit or arbitration proceeding which is pending. Suit may exist even without the fact that there is any suit or proceeding pending. So there may or may not be, because it says existence of a dispute, if any, or record of pendency of the suit or arbitration proceeding filed before the receipt. So you cannot say that unless a suit is filed, there is no dispute. The dispute could exist even without a suit or arbitration proceeding having been filed.
Suit exists, dispute exists.
Yes, dispute exists. Yes.
Dispute is.
So respondent argued that section 6 covers only 3 things. 3(6) actually they want to say. Namely, existence of the amount of debt, quality of goods or services, or breach of a representation of warranty. And since what was sought to be brought as a defense was that the non-disclosure agreement was breached, it would not come within the definition of dispute under section 3, subsection 6. So ये जो है section 3, subsection 6. So basically इसमें ये section 5 है actually, 3 भी नहीं है, ये 5 है, 5 subsection. ये है 5. So they said that if dispute exists, then this application cannot be entertained. ये basic issue. Non-disclosure agreement. So what were the issues? How to interpret the existence of dispute? What is the scope of determination by tribunal while examining applications under section 9? Whether the word and occurring in section 8 to A should be read as or. Whether the test of bona fide dispute holds good whether it is open to the adjudicating authority to go into whether a dispute does or does not exist, and whether in facts of the case dispute exists falling within inclusive definition which is contained in section 5, subsection 6. So Supreme Court dismissed the appeal in this case. Next question is Dharni Sugar. So in Dharni Sugar, what happened was that there is a circular, there was a circular by
RBI.
This RBI. And under this case, the constitutional validity of section 35AA and 35AB of the Banking Regulation Act was challenged. So these were the two issues in this case.
Order visa for order visa.
अच्छा ये जयंत जी म्यूट कर लीजिए अपने को, आपके यहाँ से कुछ आवाज आ रही है. So actually here when IBC came, RBI issued a circular whereby they instructed the banks that whenever there is a dispute, you please file applications under IBC. But the point here was, what was challenged was that the banks were instructed without looking into the facts of each and every case specifically that they were filing applications. So this circular was struck down. But Supreme Court said that, okay, we uphold that RBI being the regulator, of course, it has got certain regulatory powers. ठीक है ना? And they cannot be said to be manifestly arbitrary. And as the court category held that the plea of constitutional validity fails. ठीक है ना? कि भाई इसमें ऐसा नहीं है कि भाई constitutional validity नहीं है ये. But बात ये है कि you have to look at the specific circumstances of the case. So SC held the impugned circular to be ultra vires as a whole and declared to be of no effect in law. Consequently, all actions taken under this circular must fall along with the said circular. But in some situations, CIRP was complete. A resolution plan was passed. So Supreme Court said that in case a resolution plan has already been approved by the COC, then those cases will not be touched. But wherever CIRP is pending, so it will be treated as non-esteemed law. So that was the basic of this Dharni Sugar case. Next case था आपका Pioneer Urban Land and Infrastructure versus Union of India. इसमें issue क्या था? इसमें ये था कि representation in COC by authorized representative of allottees as delay in completion of under construction apartments has become a common phenomena, and whether deemed allottees of real estate project can be considered financial creditors and application under section 7 is allowed. So because these home buyers, they have got remedy under RERA also. So Supreme Court said that first of all, the home buyers have got remedy under RERA also, but RERA has to be read harmoniously with IBC. In case of any conflict between RERA and IBC, IBC will prevail. Then amount raised under home buyers contracts is a significant amount because basically the builders base on their projects on the finance which is given by the home buyers, which contributes to the financing of the construction of an asset in the future. So on a plain reading of section 5(8)(f), it is clear that it is a residuary entry to cover debt transactions not covered under any other entry. And the essence of the entry is that the amount should have been raised under a transaction having the commercial effect of a borrowing. And in case of home buyers, the amounts raised under the contracts of home buyers are in effect for the purpose of raising finance and are a means of raising finance. Thus, the committee deemed it prudent to clarify that such amounts raised under a real estate project from a home buyer fall within the entry F of section 5(8). So further it may be noted that the amount of money given by home buyers as advances for their purchase is usually very high, and frequent delays in delivery of possession may thus have a huge impact. So they said the current definition of financial debt is sufficient to include the amounts raised from home buyers allottees under a real estate project, and hence they are to be treated as financial creditors under the code. Such creditors fall within the definition of financial creditor by inserting an explanation to 58F of the code. So they said the Amendment Act to the code does not infringe Article 14, 19, 1G, read with Article 19(6) or 300A of the Constitution of India. RERA is to be read harmoniously with the code as amended by the Amendment Act. It is only the event of conflict that the code will prevail over the RERA. Remedies that are given to allottees of flats or apartments are therefore concurrent remedies. Such allottees of flats, apartments being in a position to avail the remedies under the Consumer Protection Act, RERA, as well as IBC. Now, next case is ArcelorMittal. ArcelorMittal.
Sir, one question. So just one query. Can I
Yes.
ask?
Yes,
Yeah,
yes,
this is regarding Kirusa software.
yes.
When the appeal got rejected and finally the payment would have been made to Kirusa. So any records IP need to create and maintain on this, the payments also which has been made to the company?
सर अपील उसका रिजेक्ट हुआ तो इट मींस he was not considered as a operational creditor and he was not entitled to do this payment वो
Okay,
करेगा
okay.
नहीं करेगा वो सिविल में जाए उसका मतलब ये है
अब
Okay,
तो
actually,
सिविल कोड में तो देखो रेमेडी है ना, बिकॉज इट
हाँ,
इज
civil code
नॉट
में।
अ रिकवरी मैकेनिज्म. आईबीसी तो रिकवरी मैकेनिज्म तो है नहीं. If you can prove that he
Okay.
has supplied the goods, so then civil court may allow some compensation. They may say that, okay,
Okay.
for this non-disclosure agreement, for breach of this non-disclosure agreement, you will be required to pay the penalty, and balance payment may be made, and things like that. Basically, the courts answer only the specific question, because this was an application filed under section 9. So they said application under 9 cannot be admitted because a dispute
Okay.
exists. That was the brief question which was asked, which was answered by the Supreme Court.
Okay.
Now,
Okay.
whether
There was
this
some
amount
correction.
is recoverable or not, so the courts will see. Civil court.
Okay. 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 Sir.
Now, ArcelorMittal, ArcelorMittal versus Satish Kumar Gupta. इसमें था क्या केस? इसमें ये था कि eligibility to submit a resolution plan. Basically, that was the issue. So, CIRP of SR Steel India Limited was initiated under Section 7, and Satish Kumar Gupta was appointed as IRP. During submission of resolution plan, ArcelorMittal and New Metal India, New Metal Limited submitted an expression of interest. A resolution professional found both to be ineligible under 29A. So this was the basic issue. So the eligibility to submit resolution plan as per section 29AC, which talks of this NPA. So they said that if somebody is controlling a company which is having NPA account and that has remained NPA for the past 1 year, so then such an applicant cannot submit a resolution plan. This is the base of 29AC. So what was the decision basically? The decision was, they said that any person who wishes to submit a resolution plan, if he or it does so acting jointly or in concert with other persons, which persons or other persons happen to either manage or control or be promoters of a corporate debtor which is classified as NPA and whose debts have not been paid off for a period of at least 1 year before commencement of CIRP, becomes ineligible to submit a resolution plan. This we all know. So the first proviso to subsection C makes it clear that the ineligibility can only be removed if the person submitting a resolution plan makes a payment of all overdue amounts, because there is a proviso also that if they make payment of all the overdue amounts with interest thereon and charges, so then they can submit the plan. So expression before submission of plan contained in the proviso. So it must be read in a commercially sensible manner. It is clear that there may be persons who may submit resolution plans either by themselves or in concert or jointly with other persons who do not have debts which are declared as NPA. So if it is shown on facts that a reasonable proximate point of time before the submission of a resolution plan, the affairs of the persons referred to in section 29A are so arranged as to avoid paying of the debts of the non-performing asset concerned, such persons must be held to be ineligible to submit a resolution plan. Or otherwise, both the purpose of the first proviso to subsection C of 29A as well as the larger objective sought to be achieved by the said subclause in public interest will be defeated. So basically they said that only those persons are eligible who do not fall foul of subclause G, who are eligible to submit resolution plans under subclause C of 29A. Because this new metal was incorporated 7 days before submission of the expression of interest. And adjudicating authority, being the NCLT, passed its order in all the interlocutory applications and held that there is no patent illegality in the decision of the resolution professional for declaring ineligible to applicants, which is a prudent decision where there is possibility of more than one legal view when the court at this stage is not expected to substitute its view and to interfere with the conclusion of the IRP. So they said that the decision of the RP is correct but they said that okay, once they pay, they can become resolution applicants. But without paying, they cannot. Sometimes what happens is that the resolution applicants try to say bypass this. What they will do? They will show as if they do not have any connection with the company which is having NPA accounts. So this is the basic issue. So Supreme Court said that if they arrange their affairs in such a way so as to avoid paying of the debts of the NPA concerned, such persons must be held to be ineligible. Because patently they may not be ineligible, but they might have distanced themselves from such companies which are having NPA accounts. This is the point basically. So they said if such payments are made within the aforesaid period, then both resolution applicants can submit their resolution plans. Now, committee of creditors. So we'll briefly see all the cases. Let us see how much we can cover. And then you can go through this presentation in detail. And if you want to read further, then you have to go to the case law. Committee of creditors of SR Steel versus Satish Kumar Gupta. So what was the basically facts? So the group appeals and writ petitions raised important questions as to the role of RP, RA, COC that are constituted under the IBC. So first of all, they dwelt upon the role of the prospective resolution applicant. So they said he has right to receive complete information as to the CD, debts owed by it, and its activities as a going concern prior to the commencement of CIRP. Also, information contained in the information memorandum as well as the evaluation matrix. Now, what is the role of COC? It is the commercial wisdom of the COC to decide as to whether or not to rehabilitate the CD by accepting a particular resolution plan. Now, what is the jurisdiction of A and NCLT? So they said the limited judicial review available to adjudicating authority has to be within the four corners of section 30 subsection 2 of the code. In respect of NCLT, it has to be within the parameters of section 32, read with section 61 subsection 3, in which grounds are given on which an appeal can be made. Such a review can in no circumstances trespass upon a business decision of the majority of COC. The residual jurisdiction of the NCLT under section 60 subsection 5C cannot in any manner whittle down section 31 subsection 1 of the code by the investment of some discretionary or equity jurisdiction in the AA outside section 30 subsection 2 of the code while adjudicating a resolution plan. Then they discussed about this secured and unsecured creditors also. So what they said? They said that protecting creditors in general is no doubt an important objective. Protecting creditors from such others is also important. If an equity for all approach recognizes the rights of different classes of creditors as part of an insolvency resolution process is adopted, secured financial creditors will in many cases be incentivized to vote in liquidation rather than resolution, as they would have better rights if the CD is liquidated. This would defeat the objectives of the code, which is resolution of distressed assets, and only if the same is not possible should liquidation follow. Equitable treatment is to be accorded to each creditor depending upon the class to which it belongs, secured or unsecured, financial or operational. Then constitution of subcommittees of COC. Another question which came here was whether COC can constitute subcommittees, and it was answered in affirmative. And they said, but these could be administrative functions in nature. So the powers of the COC in respect of matters which have vital bearing on the running of the business, though are administrative in nature, shall not be delegated to any other person. COC alone must take the decisions mentioned in section 28, but certain routine duties, so they may be given to the subcommittees. So the court said that it doesn't mean that subcommittees cannot be appointed for the purpose of negotiation with the resolution applicants or for the purpose of performing other ministerial or administrative acts. Okay, provided such acts are in the ultimate analysis approved and ratified by the committee of creditors. Next point was regarding this extinguishing of rights of the creditors against guarantors. So section 31, subsection 1 of the code makes it clear that once a resolution plan is approved by the COC, it shall be binding on all the stakeholders, including guarantors. This provision ensures that the successful resolution applicant starts running the business of the CD on a fresh slate as if it were. Now, utilization of profits of CD during CIRP. This was another point which was discussed in the court. So they said that there may be a situation where the CD may be running having some profits, but such profits cannot be distributed towards payment of debts of any creditor. Then constitutional validity of the IBC Amendment Act 2019. The legislature must be given free play in the joints when it comes to economic legislation. Apart from the presumption of constitutionality which arises in such cases, the legislative judgment in economic choices must be given a certain degree of deference by the courts. So this constitutional validity of amendment in section 12, that was also upheld. Regarding claims also, they discussed this point that a successful resolution applicant cannot suddenly be faced with undecided claims after the resolution plan submitted by him has been accepted, as this would amount to a hydra head popping up, which would throw into uncertainty amounts payable by the successful resolution applicants. The resolution plan of ArcelorMittal was also discussed, and the Supreme Court said ultimately it is the commercial wisdom of the requisite majority of the COC that must prevail on the facts of any given case, which would include distribution of assets. It is therefore not possible that the A and consequently the NCLAT would be vested with the discretion that is vested in the COC. So said that adjudicating authority or appellate authority cannot replace the commercial wisdom of COC. The COC does not act in any fiduciary capacity to any group of creditors. On the contrary, it is to take a business decision based upon ground realities by a majority, which then binds all stakeholders, including dissenting creditors.
Sir, during CRP, if there is a loss, what will be the treatment scenario?
No, loss or profit, actually, what is the idea? The idea during CIRP is to keep it as a going concern. Suppose
Yes.
they are making payments for certain supplies. So naturally,
Yeah.
what they will do? So they will go on making payment. But the another duty of the RP is protection and preservation of assets. And loss, it leads to erosion in the value. So naturally, much loss will not be allowed. There might be some loss, but suppose it is a substantial loss. That means RP is not able to make a commercial decision. No?
Okay.
So that is the idea.
Yeah.
The idea is, suppose there is a minimum loss, but if the company is sold as a going concern, then it fetches higher value. What is the ultimate aim? Ultimate aim is the maximization of the interest of all stakeholders.
Yeah.
So the loss which is now being incurred after the admission, that should not outweigh the maximization.
Okay.
That should not
Okay.
lead to destruction in value. That is the basic idea.
Okay.
Now, this BK educational case. So what was the issue here? So they said this section 238A of the IBC, which was inserted. by
Sorry
the
sir,
second-
sorry for interrupting.
Yes.
ये बीके उसमें एसआर स्टील में सर वजह सम टाइम लिमिट का भी कुछ जजमेंट था ना 330 डेज के अंदर होना चाहिए.
हाँ वो भी था.
बस
हाँ,
उसको
वो जो पॉइंट था ना उसमें क्या हुआ था, उसमें ये था कि ये भी डिस्कस कर लेता हूँ. तो
जी.
टाइम टेकन इन लीगल प्रोसीडिंग्स कैनॉट पॉसिबली हार्म ए लिटिगेंट इफ द ट्रिब्यूनल इटसेल्फ कैनॉट टेक अप द litigant's case within the requisite period for no fault. Sometimes what happens is there are litigation, so it leads to delay. So they said a provision which mandatorily requires the CIRP to end by a certain date without any exception thereto may well be an excessive interference with a litigant's fundamental right to non-arbitrary treatment under Article 14, and therefore unreasonable restriction on a litigant's fundamental right to carry on business under Article 19(1)(g) of the Constitution of India. However, the time taken in legal proceedings is certainly an important factor which causes delay and which has made previous statutory experiments fail. So it is only in exceptional cases that time can be extended. The general rule being that 330 days is the outer limit within which the resolution of the stressed assets of the CD must take place, beyond which it is to be driven into liquidation. So this point was also discussed. Now BK educational. तो BK educational में इशू क्या था? BK educational में ये था कि ये लिमिटेशन एक्ट पर केस था बेसिकली. So section 238A of the IBC, which was inserted by the IBC Second Amendment Act with effect from 6th of June 2018, because this IBC came in December 2016, but this amendment came 238A, it came in with effect from 6th June 2018. In all the cases, the appellate authority has held that the Limitation Act does not so apply. So the issue was whether the Limitation Act 1963 will apply to applications that are made under Section 7 and or Section 9 of the Code on and from its commencement on 1st December till 6th June. So this was the precise issue, basically. Retrospective application. Supreme Court analyzed this issue and they said that what is the reason for the introduction of Section 238A into the code. The committee unanimously agreed that the intent of the code could not have been to give a new lease of life to debts which are time barred. Then applicability of Limitation Act on Section 7 and 9 application. The Limitation Act is applicable to applications filed under Section 7 and 9 of the code from the inception of the code, that is 1st of December 2016. Article 137 of the Limitation Act gets attracted. The right to sue therefore accrues when a default occurs. If the default has occurred over 3 years prior to the date of filing of the application would be barred under Article 137 of the Limitation Act, save and except in those cases where, in the facts of the case, Section 5 of the Limitation Act may be applied to condone the delay in filing such application. So, retrospective fact. Limitation being procedural in nature would ordinarily be applied retrospectively, save and except that the new law of limitation cannot revive a dead remedy. The amendment of Section 238A would not serve its object unless it is construed as being retrospective, as otherwise applications seeking to resurrect time-barred claims would have to be allowed, not being governed by the law of limitation. They said, what is the definition of debt? Debt due is due and payable in law, that is not time-barred. Delayed claims are not allowed in IBC until and unless condoned under Section 5 of the Limitation Act, regarded as time-barred. So final decision, the Limitation Act has in fact been applied from the inception of the code. It is unnecessary for us to go into the argument based on the doctrine of laches. The appeals are therefore remanded to the NCLAT to decide the appeals afresh in the light of this judgment. Now Chitra Sharma versus Union of India. चित्रा शर्मा वाले केस में क्या था? चित्रा शर्मा वाला जो केस है, इसमें कहानी ये थी कि जयप्रकाश एसोसिएट्स लिमिटेड was classified under SMA2 category. Demands overdue for more than 60 days by banks as early as on 3rd October 2014, and as an NPA since 31st March 2015. RBI submitted that any further delay in resolution would adversely impact a viable resolution being found by Jayaprakash Associates Limited and Jayaprakash Industries Limited. The facts which have emerged before the court from the application filed by the RBI clearly indicate the financial distress of JAL and GIL. The apprehensions of the home buyers in regard to their financial incapacity is borne out by RBI as a responsible institution has urged before the court. Proceedings have been initiated under Article 32 of the Constitution for protecting the interest of home buyers in projects floated by JP Infratech Limited. JIL is a special purpose vehicle created by its holding company Jayaprakash Associates Limited. Now, what are the issues involved in this case? The issues involved is, ये तो खैर काफी सारी जजमेंट है इसमें, तो पहला तो ये है इसमें कि declaration that section 6, 7, 10, 14 and 53 of the code are ultra virus insofar as only financial or operational creditors are recognized, disregarding other stakeholders such as home buyers. The order dated 9th August 2017 of the NCLT be set aside. The Union of India be directed to notify under section 14.3 that the provisions for moratorium contained under section 14.1a shall not apply to consumers, and that home buyers be allowed to exercise the rights available to them under the Consumer Protection Act and the RERA Act. Forensic audit of GIL and JAL be conducted for the period from 2009 to 2017. A direction be issued to the Union of India to protect the interest of home buyers in the larger public interest. Now, what was the decision basically? So the decision was, दूसरा केस आ गया अनुज जैन वाला, तो इसमें हुआ क्या था? All bids must follow the discipline of the IBC. Court, however, has not accepted the submission to allow GIL or JL and the erstwhile promoters to participate in the process. Their participation is expressly prohibited by section 29A, and we decline to make an exception which would breach a salutary and express provision made in the IBC. Amendment in section 30. Parliament rectified a loophole in the Act which allowed a backdoor entry to erstwhile managements in the CIRP. Section 30 of the IBC, as amended, also clarifies that a resolution plan of a person who is ineligible under 29A will not be considered by the COC. Now, interests of home buyers safeguarded. The IBC has been enacted in the form of a comprehensive bankruptcy law and with a specific legislative intent. With the amendment brought about by the ordinance promulgated in June 2018, the interest of the home buyers have been sought to be safeguarded. Accordingly, we accede to the request made on behalf of the RBI to allow it to follow the recommendation to initiate CIRP against JAL under IBC. Now, what were the directions which were issued by the court? In exercise of the powers vested in this court under Article 142 of the Constitution, we direct that the initial period of 180 days for the conclusion of the CIRP in respect of GIL shall commence from the date of this order. So they said that 180 days will start from this date, from the date of the order. If it becomes necessary to apply for the further extension of 90 days, we permit the NCLT to pass appropriate orders in accordance with the provisions of the IBC. We direct that the COC shall be constituted afresh in accordance with the provisions of IBC, Ordinance 2018, more particularly the amended definition of the expression financial creditors. Okay, वो 58F वाला. We permit the IRP to invite fresh expression of interest for the submission of resolution plans by applicants, in addition to the 3 shortlisted bidders whose bids, or as the case may be, revised bids may also be considered. JIL, JL and their promoters shall be ineligible to participate in the CIRP by virtue of the provisions of section 29. RBI is allowed in terms of its application to this court to direct the banks to initiate CIRP against JAL under the IBC. The amount of 750 crores which has been deposited in this court by JL/JIL shall, together with the interest accrued thereon, be transferred to the NCLT and continue to remain invested and shall abide by such directions as may be issued by the NCLT. तो ये केस था. अगला केस हमारा है अनुज जैन IRP for JP Infratech versus Axis Bank. इसमें क्या केस था बेसिकली? So JP Infratech is the corporate data company in whose relation CIRP is pending, and mortgage transactions concerning its properties were questioned in the application filed by the IRP. ठीक है? Jayaprakash Associates Limited is the holding company of JIL. It had approximately 71.64% equity shareholding in JIL. The impugned mortgage transaction were entered into in favor of its lenders. And then lender said that once the CIRP of JP Infratech is taking place, so we should also be allowed as in the COC. This was the issue.
The properties of
Property थी JP Infratech की,
जेल की प्रॉपर्टी थी ना सर?
JIL की प्रॉपर्टी थी,
हाँ, JIL की property।
JIL के लेंडर्स थे ना, उनको
जी, जी, जी।
मॉर्गेज कर दी, तो
Yes,
JIL
yes।
के लेंडर्स ने बोला भाई हमें भी उसकी COC में ले लो।
हाँ, FC बना लो हमें भी।
हाँ, उन्होंने कहा नहीं ऐसा नहीं हो सकता।
नहीं, ऐसा नहीं हो सकता।
एक तो PUFE एप्लीकेशन थी, तो whether the
Right.
transaction in question deserves to be avoided as being preferential, undervalued and fraudulent. दूसरा, whether the respondents, lenders of JIL could be recognized as financial creditors of the corporate debtor JIL on the strength of the mortgage created by the corporate debtor as collateral security of the debts. तो डिसीजन हुआ क्या इसमें? डिसीजन ये हुआ कि whether a transaction of transfer of property or an interest thereof of the corporate debtor falls squarely within the ambit of section 43 preferential. Ordinarily, the following questions shall have to be examined. पहला क्या है? As to whether such transfer is for the benefit of a creditor or surety or guarantor. ठीक है, 43 में लिखी ये बात.
Right.
As to whether such transfer is for or on account of an antecedent financial debt or operational debt or other liabilities owed by the corporate debtor. As to whether such transfer has the effect of putting such creditor or surety or guarantor in a beneficial position, then it would have been in the event of distribution of assets being made in accordance with section 53. If such transfer had been for the benefit of a related party other than an employee, as to whether the same was made during the period of 2 years preceding the insolvency commencement date, and if such transfer had been for the benefit of an unrelated party, as to whether the same was made during the period of 1 year preceding the insolvency commencement date, as to whether such transfer is not an excluded transaction. ठीक है, जो normal course of business. There is nothing to doubt that the corporate debtor GIL has given a preference by way of the mortgage transactions in question for the benefits of its related person. Okay, JIL, who has been the creditor as also surety for GIL for or on account of an antecedent financial debt, operational debt and other liabilities owed to such related person. In the given fact situation, it is plain and clear that the transaction in question meets with all the requirements of clause A of subsection 2 of section 43. The impugned transactions had been of transfers for the benefit of JAL, who is a related party of the corporate debtor JIL, and it is its creditor and surety by virtue of antecedent operational debts as also other facilities extended by it, and the impugned transaction has the effect of putting JIL in a beneficial position. Then it would have been in the event of distribution of assets being made in accordance with section 53. Thus, the corporate debtor GIL has given a preference in the manner laid down in subsection 2 of section 43. Lenders of JIL on the strength of the mortgages in question may fall in the category of secured creditors, but such mortgages being neither towards any loan, facility or advance to the corporate debtor. भाई उन्होंने कहा लोन दिया किसको है? JIL को तो दिया नहीं, है ना?
JIL को
Nor towards protecting any facility or security of the corporate debtor. It cannot be said that the corporate debtor owes them any financial debt. कि भाई JIL ने तो उनको कुछ नहीं देना ना, JIL ने देना within the meaning of section 58 of the code. And hence, lenders of JAL do not fall in the category of financial creditors of the corporate debtor JIL. ये केस. अगला केस है स्विस रिबन्स का. स्विस रिबन्स वर्सेस यूनियन ऑफ इंडिया. इसमें बहुत सारे चैलेंजेस थे. वेरियस पॉइंट्स वर देयर. पहला तो ये था अपॉइंटमेंट ऑफ मेंबर्स ऑफ NCLT एंड द NCLAT not contrary to this court's judgment. So this selection committee was reconstituted on 22nd February 2017 to make further appointments in compliance with the directions of this court Advertisements dated 10th August were issued inviting applications for judicial and technical members, as a result of which all the present members of the NCLT and NCLAT have been appointed. So their appointment was challenged. So the Supreme Court said that the selection committee, it has been reconstituted in compliance of the directions of this court. So their appointment is valid. Second issue was that NCLAT is only having its office at Delhi. If you want to file an appeal, तो इंडिया में पहले तो क्या होता था कि भाई हर जगह हाई कोर्ट तो हर जगह पर है, वहां अपील फाइल हो जाती थी. तो सुप्रीम कोर्ट ने कहा कि सर्किट बेंचेस विल बी एस्टैब्लिश्ड एज सून एज इट इज प्रैक्टिकेबल. अगला पॉइंट इसमें था कि क्लासिफिकेशन बिटवीन फाइनेंशियल क्रेडिटर्स एंड ऑपरेशनल क्रेडिटर्स, neither discriminatory nor arbitrary nor violative of Article 14 of the Constitution of India. तो उन्होंने कहा कि भाई ये जो दोनों टाइप्स ऑफ क्रेडिटर्स हैं, दे फॉल ऑन डिफरेंट फुटिंग. सो फाइनेंशियल क्रेडिटर्स आर फ्रॉम द वेरी बिगिनिंग इन्वॉल्व्ड विद असेसिंग द वायबिलिटी ऑफ द कॉर्पोरेट डेटर. They can and therefore do engage in restructuring of the loan as well as reorganization of the corporate debtors business when there is financial stress, which are things operational creditors do not and cannot do. Preserving the corporate debtor as a going concern while ensuring maximum recovery for all creditors being the objective of the code, financial creditors are clearly different from operational creditors, and therefore there is obviously an intelligible differentia between the two, which has a direct relation to the objects sought to be achieved by the code. एक और पॉइंट था इसमें कि सेक्शन 21 and 24 and आर्टिकल 14 ऑपरेशनल क्रेडिटर्स हैव नो वोट इन द कमिटी ऑफ क्रेडिटर्स. ठीक है, तो NCLAT has, while looking into the viability and feasibility of resolution plans that are approved by the committee of creditors, always gone into whether operational creditors are given roughly the same treatment as financial creditors, and if they are not, such plans are either rejected or modified so that the operational creditors' rights are safeguarded. It may be seen that a resolution plan cannot pass muster under section 32B of read with section 31 unless a minimum payment is made to operational creditors, being not less than the liquidation value. Further, on 5th October 2018, Regulation 38 has been amended, which further strengthens the rights of operational creditors by statutorily incorporating the principle of fair and equitable dealing of the operational creditors' rights together with priority in payment over financial creditors. Okay. Then section 12A. Section 12A was also challenged. तो सेक्शन 12A पे क्या इशू था? सेक्शन 12A का इशू ये था कि भाई ये जो है the main thrust against the provisions of section 12A is the fact that 90% of the committee of creditors has to allow withdrawal. वो बोले 90 बहुत ज्यादा है. This high threshold has been explained in the ILC report as all financial creditors have to put their heads together to allow such withdrawal, as ordinarily an omnibus settlement involving all creditors ought ideally to be entered into. This explains why 90%, which is substantially all the financial creditors, have to grant their approval to an individual withdrawal or settlement. In any case, the figure of 90%, in the absence of anything further to show that it is arbitrary, must pertain to the domain of legislative policy, which has been explained by the report. Also, it is clear that under section 60 of the code, the committee of creditors do not have the last word on the subject. If the committee of creditors arbitrarily rejects a just settlement and or withdrawal claim, the NCLT and thereafter the NCLAT can always set aside such decision under section 60 of the code. For all these reasons, we are of the view that section 12A also passes constitutional muster. Now, evidence provided by the private information utility. उन्होंने कहा भाई this is only prima facie evidence of default. ठीक है, it is only prima facie evidence of default which is rebuttable by the corporate data, makes it all clear that the challenge based on this ground must also fail. ठीक है. Another point was regarding this resolution professional, so whether he has got any adjudicatory powers or not. ये वाला भी एक इशू था इसमें. तो इसमें इशू क्या आया था? इसमें ये था कि when the liquidator determines the value of claims admitted under section 40, such a determination is a decision which is quasi-judicial in nature and which can be appealed against to the adjudicating authority. under section 42 of the code. Unlike the liquidator, the RP cannot act in a number of matters without the approval of the committee of creditors under section 28 of the code, which can, by a 2/3 majority, replace one resolution professional with another in case they are unhappy with his performance. Thus, the resolution professional is really a facilitator of the resolution process, whose administrative functions are overseen by the COC and by the adjudicating authority. Then constitutional validity of section 29A. So they said this 29AC is also okay. The legislative purpose which permeates section 29A continues to permeate the section when it applies not merely to resolution applicant but to liquidation also. The 1 year period in section 29AC and NPS. A person who is unable to service its own debt beyond the grace period referred to above is unfit to be eligible to become a resolution applicant. This policy cannot be found fault with, neither can the period of 1 year be found fault with, as this is a policy matter decided by the RBI and which emerges from its master circular, as during this period an NPA is classified as a substandard asset. The ineligibility attaches only after this 1 year period is over, as the NPA now gets classified as a doubtful asset. Related parties. All the categories in section 29J deal with persons natural as well as artificial who are connected with the business activity of the resolution applicant. The expression related party, therefore, and relative contained in the definition sections must be read nocitur soices with the categories of persons mentioned in explanation 1, and so read would include only persons who are connected with the business activity of the resolution applicant. Any such person is not indeterminate at all, but is a person who is in the saddle of the business of the corporate debtor, either at an anterior point of time or even during implementation of the resolution plan. Then exemption of this micro, small and medium enterprises from section 29A. तो इस केस में क्या था, ये जो सेक्शन 240A, सेक्शन 240A में क्या बोलता था? The rationale for excluding such industries from the eligibility criteria laid down in 29AC and 29AH is because qua such industries, other resolution applicants may not be forthcoming, which then will inevitably lead not to resolution but to liquidation. Falling upon the Insolvency Law Committee's report, section 240A has been inserted in the code with retrospective effect. Then section 53 of the code does not violate article 14. Unsecured debts are of various kinds, and so long as there is some legitimate interest sought to be protected having relation to the object sought to be achieved by the statute in question, article 14 does not get infracted. For these reasons, the challenge to section 53 must also fail. अगला केस है हमारा बाबूलाल वर्धर जी गुर्जर वर्सेस वीर गुर्जर एल्यूमिनियम. इसमें केस क्या था? इसमें केस बेसिकली ये था कि whether the application made by Veer Gurjar Aluminium Industries Limited under section 7 of the code is within the limitation period. ठीक है, लोन मिला था 2007 में, ठीक है, कॉर्पोरेशन बैंक, बैंक ऑफ इंडिया एंड IOB दे एक्सटेंडेड लोन्स. ठीक है, किसको दिया था? ये वीर गुर्जर एल्यूमिनियम इंडस्ट्रीज को. ठीक है, और डायरेक्टर इसके थे ये बाबूलाल वर्धर जी गुर्जर. ईयर 2011 में हो गया डिफॉल्ट एंड दिस अकाउंट वाज डिक्लेयर्ड NPA. मार्च 2013 में कॉर्पोरेशन बैंक ने क्या किया? अपना डेट असाइन कर दिया JM फाइनेंशियल कॉर्पोरेशन. ठीक है, फिर मार्च 2013 में IOB इनिशिएटेड एक्शन अंडर सरफेसी. फिर आ गया 2018, सरफेसी प्रोसीडिंग वाज पेंडिंग बिफोर DRT. और ईयर 2018 में जो JM फाइनेंशियल थी, इन्होंने सेक्शन 7 की एप्लीकेशन लगा दी क्योंकि दे वर द असाइनी ऑफ द डेट. ठीक है, एंड एडजुडिकेटिंग अथॉरिटी एडमिटेड द एप्लीकेशन अंडर सेक्शन 7. सो बीइंग एग्रीव्ड विद द डिसीजन ऑफ ए, appellant preferred an appeal before NCLAT. NCLAT ने क्या कहा? NCLAT held that neither the application under section 7 is barred by limitation nor the claim of respondent number 2 is so barred and has therefore dismissed the appeal. अब मामला चला गया सुप्रीम कोर्ट में. ठीक है, तो सुप्रीम कोर्ट ने कहा कि भाई ये उन्होंने इसी बात पर डिलिब्रेट किया कि ये जो है ये लिमिटेशन में है या नहीं है. तो वेदर द एप्लीकेशन made by Veer Gurjar Aluminium Industries under section 7 of the code is within limitation period. तो सुप्रीम कोर्ट ने कहा कि डेट ऑफ डिफॉल्ट क्या लोगे आप? डेट ऑफ डिफॉल्ट लोगे आप डेट ऑफ एनपीए, ठीक है? जब एनपीए हो गया तो उसको आप डिफॉल्ट लो। An application under section 7 of the code is not for enforcement of mortgage liability, and article 62 of the limitation act does not apply to this application. तो उन्होंने कहा देखो, एक तो होता है आर्टिकल 62। आर्टिकल 62 तो अप्लाई कब होता है? जब आप when you are trying to enforce the mortgage, ठीक है? उसका पीरियड 12 years है, ठीक है? और नॉर्मल लिमिटेशन पीरियड आपको मालूम है कि वो 3 years है, ठीक है? So period of limitation for an application seeking initiation of CIRP is governed by Article 137, ठीक है? And therefore 3 years from the date when the right to apply accrues. The trigger for initiation of CIRP by financial creditor is default, ठीक है? Default referred to in the code is that of actual non-payment by the corporate debtor when a debt has become due and payable. That if default had occurred over 3 years prior to the date of filing of the application would be time barred. ठीक है? Save and except in those cases where on facts the delay in filing may be condoned. ठीक है? तो डेट ऑफ डिफॉल्ट आपको क्या लेनी है? डेट ऑफ एनपीए। अब इसमें इशू ये आया कि whether section 18 of limitation act could be applied to the present case. So prima facie it appears that illustrative reference to section 18 of the limitation act had only been in relation to suit or other proceedings wherever it could apply and where the period of limitation could get extended because of acknowledgement of liability. Noticeably, in contradistinction to the proceedings of a suit, this court observed that a suit for recovery, which is a separate and independent proceeding, distinct from the remedy of winding up, would in no manner impact the limitation within which the winding up proceeding is to be filed. In BK Educational Services, it has clearly been held that the limitation period for application under section 7 of the code is 3 years, as provided by Article 137 of the limitation, which commences from the date of default and is extendable only by application of section 5 of the limitation act. If any case for condonation of delay is made out under section 7 of the code in the month of March 2018, seeking initiation of CIRP in respect of the corporate debtor with specific assertion of the date of default as 8th July 2011. इन्होंने कहा भाई आपने ये क्या कहा इसमें कि हमारा डिफॉल्ट कब हुआ है? 8th जुलाई को। आपने स्पेसिफिकली इंसर्ट किया है, तो ये तो इट इज वे बियॉन्ड लिमिटेशन पीरियड. It is clearly barred by limitation for having been filed much later than the period of 3 years from the date of default as stated in the application. NCLT having not examined the question of limitation, NCLT having decided the question of limitation on entirely irrelevant considerations, and the attempt on the part of the respondents to save the limitation with reference to the principles of acknowledgement having been found unsustainable, the impugned orders deserves to be set aside, and the application filed by the respondent number 2 deserves to be rejected as being barred by limitation. अगला केस आपका केस शशिधर वर्सेस इंडियन ओवरसीज बैंक. 1 मिनट दीजिए मेरे को, जरा मैं पानी पी लूंगा, प्यास लग गई थोड़ी. हाँ जी, तो इस केस में क्या हुआ था? केस शशिधर वाले केस में, केस शशिधर में इशू क्या था? पहले तो ये जो कॉर्पोरेट डेटा था KSPIPL and Innovative Industries, they filed CIRP application under section 10, which was accepted by NCLT, and IRP was appointed in February 2017. However, the resolution plan was approved by 66.67% instead of 75. पहले ये ना 75% मेजोरिटी होती थी COC में भी, अब 66 हो गई है. पहले क्या होती थी? 75%. तो जब 75 थी तो ये अप्रूव हुआ था with 66.67%. ठीक है? Still, NCLT approved it via its order dated 3rd November 2017. So aggrieved financial creditors complained to NCLT, which said that 75% voting is mandatory and adjudicating authority cannot disregard the same. ठीक है? अब क्वेश्चन इसमें ये आया कि भाई ये जो फ्रॉम 75 टू 66 एक पर्टिकुलर डेट को हुई थी, उससे पहले जितने भी प्लान अप्रूव हुए उसको 75% मेजोरिटी से होने चाहिए थे। ठीक है, कुछ क्रेडिटर्स पहुंच गए कि जी अब तो चेंज हो गया है, तब तक प्लान अप्रूव नहीं हुआ था, सीओसी ने 66% मेजोरिटी के साथ जो है वो अप्रूव करके उनको दिया था। अब इशू इन्वॉल्व ये था कि ये जो अमेंडमेंट हुआ है फ्रॉम 6 जून 2018 रिगार्डिंग रिड्यूसिंग द थ्रेशोल्ड रिक्वायरमेंट ऑफ 75% टू 66% कैन बी अप्लाइड इन दिस केस। पहला तो ये था, ठीक है। दूसरा ये कि इफ द रेजोल्यूशन प्लान अप्रूव्ड बाय रिक्विजिट मेजॉरिटी कुड नॉट बी प्रोड्यूस्ड विद इन द स्टैट्यूटरी पीरियड, व्हाट एक्शन मस्ट बी टेकन। एनसीएलटी ने अलाउ कर दिया था, एनसीएलटी ने कहा नहीं भाई हम ये मतलब इसको अप्रूव नहीं कर सकते, ठीक है। बाद वाली इसके बाद अगर कोई केस आएगा उसी पर ये एप्लीकेबल होगा, रिट्रोस्पेक्टिव इफेक्ट से इसका एप्लीकेशन नहीं है।
Resolution plan was approved before 6 June 2018.
हाँ हाँ हाँ, बिल्कुल बिल्कुल बिल्कुल। तो अमेंडमेंट आई इसमें, अमेंडमेंट टू रेगुलेशन कैन नॉट हैव रिट्रोस्पेक्टिव इफेक्ट, बेसिकली बात ये थी। इन द फर्स्ट प्लेस द अमेंडमेंट टू रेगुलेशन कैन नॉट हैव रिट्रोस्पेक्टिव इफेक्ट so as to impact the decision of the COC of the concerned corporate debtor taken before the amendment of the said regulation. There is no indication in the code as amended or the regulations to suggest that as a consequence of this amendment, the decisions already taken by the concerned COC prior to 3rd July 2018 be treated as deemed to have been vitiated, or for that matter necessitating reversion of the proposal to COC for recording reasons, that too beyond the statutory period of 270 days. A new life cannot be infused in the resolution plan which did not fructify within the statutory period by such circuitous route. ठीक है। Commercial decision by COC, non-recording of reasons is irrelevant. The dispensation provided in the IBC is entirely different. In terms of section 30 of the IBC, the decision is taken collectively after due negotiations between the financial creditors who are constituents of the COC, and they express their opinion on the proposed resolution plan in the form of votes as per their voting share. In the meeting of COC, the proposed resolution plan is placed for discussion, and after full interaction in the presence of all concerned and the resolution personnel, the constituents of the COC finally proceed to exercise their option, business oblique commercial decision, to approve or not to approve the proposed resolution plan. In such a case, non-recording of reasons would not per se vitiate collective wisdom. Collective decision cannot be challenged. The collective decision of the financial creditors, the legislature has not envisaged challenge to the commercial wisdom or business decision of the financial creditors taken collectively, or for that matter their individual opinion, as the case may be on this count. Voting speaks everything. It is enough for the dissenting financial creditors to disprove the proposed resolution plan by voting as per its vote share based on commercial decision. Indeed, if the opposition of the dissenting financial creditors is in regard to matters within the jurisdiction of the tribunal ascribable to section 30 subsection 2 or section 61 subsection 3, then the situation may be somewhat different. But that is not the issue in these cases. Okay? So whether revised resolution plan can be taken on record? As regards the application by the resolution applicant for taking his revised resolution plan on record, the same is also devoid of merits, inasmuch as it is not open to the adjudicating authority to entertain a revised resolution plan after the expiry of the statutory period of 270 days. Accordingly, no fault can be found with the NCLT for not entertaining such application. Initiation of liquidation. Supreme Court held that NCLT has justly concluded in the impugned decision that the resolution plan of the concerned corporate debtor has not been approved with the requisite percentage of voting share of the financial creditors. And in absence of any alternative resolution plan presented within the statutory period of 270 days, the inevitable sequel is to initiate liquidation process under section 33 of the code. That view is unexceptional. Resultantly, the appeals must fail. ठीक है, तो हमने कहा भाई लिक्विडेशन ही होगा अब तो इसका, क्योंकि जो रेजोल्यूशन प्लान आया ना वो भी आया था 270 डेज के बाद में। अब अगला केस है इसमें इसका ये किशन
Yes, sir.
ये किशन वर्सेस ये
Bank
किशन
मध्ये.
वर्सेस विजय निर्माण। इस केस में क्या था? इसमें इशू इन्वॉल्व ये था कि whether the IBC can be invoked in respect of the operational debt where an arbitral award has been passed against the operational debtor which has not yet been finally adjudicated upon. ठीक है, आर्बिट्रेशन में प्रोसीडिंग चल रही है, आर्बिट्रेशन अवार्ड आ गया, उसके अगेंस्ट में अपील फाइल नहीं हुई, बट अपील का टाइम अभी पेंडिंग है। इशू ये है, रिजेक्शन ऑफ एप्लीकेशन इफ नोटिस ऑफ डिस्प्यूट रिसीव्ड। A reading of section 952D would show that an application under section 8 must be rejected if notice of a dispute has been received by the operational creditor. In the present case, it is clear on facts that the entire basis for the notice under section 8 of the code is the fact that an arbitral award was passed on 21st July 2017 against the appellant. As has been pointed out by us, this clearly appears from the gist of the case that was filed along with the insolvency petition. The fact that reply of 16/2/2017 to the notice given under section 8 was within 10 days and raised the existence of a dispute also cannot be doubted. Now reference to legislative guide. This court referred to the legislative guide on insolvency law of the United Nations Commission on International Trade Law, UNCITRAL. One of the things the legislative guide spoke about was whether the debt is subject to a legitimate dispute or set off in an amount equal to or greater than the amount of the debt. Okay. So factors to be seen on examination of application. Adjudicating authority, therefore, when examining an application under section 9 of the code, will have to determine the following. Pehla, whether there is an operational debt as defined exceeding 1 lakh that time. Whether the documentary evidence furnished with the application shows that the aforesaid debt is due and payable and has not been paid. Whether there is an existence of a dispute between the parties or the record of the pendency of a suit or arbitration proceeding filed before the receipt of the demand notice of the unpaid operational debt in relation to such dispute. Result of discrepancy of any of the conditions mentioned above. If any of the above conditions is lacking, the application would have to be rejected. Apart from the above, the adjudicating authority must follow the mandate of section 9 as outlined above, and in particular, the mandate of section 9, subsection 5 of the Act, and admit or reject the application as the case may be, depending upon the factors mentioned in section 9, subsection 5 of the Act. Now, what are the cautions to be taken by operational creditors while using IBC? So, operational creditors cannot use the IBC either prematurely or for extraneous considerations or as a substitute for debt enforcement procedures. The alarming result of an operational debt contained in arbitral award for a small amount, say 2 lakh of rupees, cannot possibly jeopardize an otherwise solvent company worth several crores of rupees. Such a company would be well within its right to state that it is challenging the arbitral award passed against it, and the mere factum of challenge would be sufficient to state that it disputes the award. The code cannot be used in terrorism to extract this sum of money of rupees 2 lakhs, even though it may not be finally payable, as adjudication proceedings in respect thereto are still pending. It is repeated that the object of the code, at least insofar as operational creditors are concerned, is to put the insolvency process against a corporate debtor only in clear cases where a real dispute between the parties as to the debt owed does not exist. ठीक, तो ये था.
Sir, 1 second, sir.
Yes, please.
Actually, you are reading from some other book rather than this material, sir.
Yes.
Acha, I think this material looks very simple, but I think better I will read this material, sir, instead of looking this thing and listening other matter.
Anyway, this material is already with you. So if you want to read from here, you can read from here also. So facts are almost same, but instead of just reading, so I'm giving you a brief overview what was the case basically. Manish Kumar versus Union of India. So in this case, what were the facts of the case? A group of allottees of real estate projects, they had challenged the constitutional validity of the amendments made by the Insolvency and Bankruptcy Code Amendment Act 2020. This petition majorly deals with the amendments inserted, 3 provisos to section 7.1, and additional explanation to section 11 and section 32A. So these were the facts. First was, what is the meaning of allottee? Then it creates a miscellany OG contentious regarding allottees. 10% is a dynamic figure and keeps changing. Also, what is 1/10 in the morning may fall short by night if more allotment is made. Because there is a proviso in section 7 which says that not less than 10% can file the application, or 100, whichever is less, rendering the filing of application impossible. What shall be the point of time to comply with the threshold requirements? Whether holdings by family members, etc., and joint holdings of a unit are considered a single allottee. If we read section 7.1 proviso, so section 7.1 proviso says that the application shall be filed jointly by not less than 100 of such allottees under the same real estate project, or not less than 10% of the total number of such allottees under the same real estate project, whichever is less. So this proviso basically was under challenge in this case. So they said that 10% may go on changing. Then there are different issues like holding by family members, joint holding. Amendments imply that the power of waiver is being denied, unlike the Companies Act. Whether it is constitutional, allottees to be from the same real estate project. So they said because the code says that they have to be from the same real estate project. So subclass cannot be created within a class. Are the amendments violative of the pioneer judgment in Pioneer Urban Land and Infrastructure? Whether right given under unamended law was a vested right, is it hampered by amendment? Then they said regarding third proviso in section 7, 10% limit is also applicable to all those applications which were filed prior to this, because this law said that, okay, within 1 month, you either get the applications amended or that will be deemed to be withdrawn. So that was another issue which came. So what was the decision? So all the impugned amendments were upheld subject to directions. Now, provision amending section 7.1 of the IBC are upheld if a single allottee is allowed to move a section 7 application, because actually earlier the limit was only 1 lakh rupees. And suppose there are 500 home buyers in a project. A particular buyer is dissatisfied, a particular home buyer. Now he cannot drag the whole company or whole project into jeopardy because of his issues. So they said that a minimum number is important or a minimum percentage is important. That was the rationale behind this judgment. So they said that if a single allottee is allowed to move a section 7 application, the interest of all the other allottees may be jeopardized and the entire project may be put into peril. All independent allotments would qualify as separate allotments and would be accounted for in the calculation of 100 allottees or 1/10 of the allottees. Now, information of home buyers can be easily gathered to make a total of 10%. So section 11(1)(b) of the RERA makes it mandatory for the promoter to make available information regarding the bookings. Regulations require the promoter to open a web page for the project and post and update information relating to allotments. So they said that it is not difficult to find the allottees. The law giver has therefore created a mechanism, namely the association of allottees, through which the allottees are expected to gather information about the status of the allotments, including the name and addresses of the allottees. Okay? So threshold only for home buyers and not for financial creditors. So there is no intelligible differentia being in excess with the object and purpose of the code. A class within a subclass is indeed not antithetical to the guarantee of equality under Article 14. The inquiry must not end with finding that there is an intelligible differentia to be found in the numerosity, heterogeneity, and individuality in decision-making of the allottees. The law further requires that the differentia must have a rational nexus with the object of the law. As laid down by this court, in dealing with the challenge on the anvil of Article 14, the court will not adopt a doctrinaire approach. regarding third proviso to section 7. It is only one time affair because the third proviso said that within 30 days, either you amend the application or it will be treated as withdrawn unless you meet this threshold. So prescribing a time limit of 30 days to modify the pending applications to comply with the threshold requirement cannot be per se described as arbitrary, as otherwise it would be an endless and uncertain procedure. Now regarding insertion of section 32A. It is not as if the wrongdoers are allowed to get away. They remain liable. The extinguishment of the criminal liability of the corporate debtor is apparently important to the new management to make a clean break with the past and start on a clean slate, because section 32A grants immunity to the new promoters. So the immunity is premised on various conditions being fulfilled. There must be a resolution plan. It must be approved. There must be a change in the control of the corporate debtor. The new management cannot be disguised avatar of the old management, and it cannot even be the related party of the corporate debtor. So these are the various issues which were discussed in this Manish Kumar versus Union of India. Now P. Mohan Raj and others versus Shah brothers. ये पढ़ा है किसी ने केस, थोड़ा बताएंगे क्या केस है? 138 का केस है बेसिकली. हाँ जी, श्याम कृष्णा जी. है क्या श्याम कृष्णा जी? चले गए श्याम कृष्णा जी? तो है अभी. तो पी मोहन राज वाला केस था क्या एक्चुअली? इसमें बेसिकली ये था कि चेक्स इशू किए थे किसने? डायमंड इंजीनियरिंग प्राइवेट लिमिटेड. ठीक है, ये थे 24 करोड़ 20 लाख के चेक्स. सो दीज वर ड्यू एंड पेएबल बाय द कंपनी टू इट्स सप्लायर शाह ब्रदर्स इस्पात प्राइवेट लिमिटेड. ठीक है, और ये सारे के सारे दीज वर रिटर्न डिसऑनर्ड. ठीक है, फॉर द रीजंस फंड्स इनसफिशिएंट. तो इस पर आ गया फंड्स इनसफिशिएंट. As a result, on 31/3/2017, the respondent issued a statutory demand notice under section 138. ठीक है, read with section 141 of the Negotiable Instruments Act, calling upon the company and its 3 directors, the appellants number 1, 1 to 3, herein to pay this amount within 15 days of the receipt of the notice. ठीक है, Negotiable Instruments Act में है कि if a check is dishonored, तो आपको क्या है? 15 days का नोटिस देना है कि भाई अब आपको पेमेंट करनी है. नहीं करेंगे तो फिर क्रिमिनल लायबिलिटी अराइज हो जाती है. तो चेक तो डिसऑनर हो गए, बैंक से लिखा हुआ आ गया फंड्स इनसफिशिएंट, इन्होंने नोटिस दिया. ठीक है, शाह ब्रदर्स ने. 2 criminal complaints were also filed by the respondent against the company and the appellants under section 138 with section 141. Application under section 9 of the IBC and directing commencement of CIRP with respect to the company, a moratorium in terms of section 14 of the IBC was ordered. ठीक है, तो उसके बाद में इन्होंने CIRP में भी एप्लीकेशन लगा दी सेक्शन 9 की. A resolution plan submitted by the promoters of the company had been approved by the committee of creditors. The adjudicating authority approved such plan, as a result of which the moratorium order dated 6th June ceased to have effect. ठीक है, नाउ इशू क्या है इसमें? इशू ये है कि whether the institution or continuation of a proceeding under section 138 or 141 of the Negotiable Instruments Act can be said to be covered by the moratorium provision, namely section 14. Now what were the arguments put forth? इसमें arguments ये रखे गए, it would be most incongruous to hold that section 138 proceeding, which although a criminal proceeding, is in essence to recover the amount of the bounced check, be kept out of the word proceedings contained in section 14(1)(a) of the IBC. Even if a criminal proceedings properly so called are to be excluded, तो पहला क्वेश्चन ये उठा कि क्रिमिनल को डिसीजन, क्रिमिनल प्रोसीडिंग को इससे एक्सक्लूड करना है या नहीं करना. तो सुप्रीम कोर्ट ने क्या कहता है? सुप्रीम कोर्ट ने कहा इवन इफ ए क्रिमिनल प्रोसीडिंग properly so called are to be excluded from section 14(1)(a), section 138 proceeding being quasi criminal in nature, whose dominant object is compensation being payable to the person in whose favor a check is made, which has bounced the punitive aspect of section 138 being only to act as interim proceeding to achieve this result, it is clear that in any event a hybrid proceeding partaking of this nature would certainly be covered. Now what was the decision? पहले तो बात प्रोसीडिंग, उन्होंने कहा प्रोसीडिंग को देख लेते हैं कि भाई प्रोसीडिंग में क्या है, क्या क्रिमिनल प्रोसीडिंग आएंगी नहीं आएंगी. तो वेदर द एक्सप्रेशन प्रोसीडिंग्स कैन बी कट डाउन टू मीन सिविल प्रोसीडिंग्स stricto sensu by the use of the rules of interpretation such as ejusdem generis and nocitur soicis. Ejusdem generis and nocitur soicis being rules as to the construction of statutes cannot be exalted to nullify the plain meaning of words used in a statute if they are designedly used in a wide sense. Importantly, where a residuary phrase is used as a catch-all expression to take within its scope what may reasonably be comprehended by a provision regarding hand to its object and setting, Neuster sources cannot be used to color an otherwise wide expression so as to whittle it down and stultify the object of a statutory provision. Section 14 in relation to other moratorium sections in the IBC. Where individuals or firms are concerned, the recovery of any property by an owner or lessor where such property is occupied by or in possession of the individual or firm can be recovered during the moratorium period, unlike the property of the corporate debtor. ठीक है भाई, बार किस पर है? बार तो रिकवरी ऑफ प्रॉपर्टी ऑफ द कॉर्पोरेट डेटर पर है ना, इंडिविजुअल की प्रॉपर्टी पर तो कोई बार नहीं है. Then interplay between section 14 and section 32A of the IBC. A moratorium provision, on the other hand, does not extinguish any liability, civil or criminal, but only casts a shadow on proceedings already initiated and on proceedings to be initiated, which shadow is lifted when the moratorium period comes to an end. Also, section 32A1 operates only after the moratorium comes to an end. At the heart of section 32A is the IBC's goal of value maximization and the need to obviate lower recoveries to creditors as a result of the corporate debtor continuing to be exposed to criminal liability. Now, the nature of the proceedings under chapter 17 of the Negotiable Instruments Act. A quasi-criminal proceeding that is contained in chapter 17 of the Negotiable Instruments Act would, given the object and context of section 14 of the IBC, amounts to a proceeding within the meaning of section 14(1)(a). The moratorium, therefore, attaching to such proceeding. Then quasi-criminal proceedings. The hybrid nature of a civil contempt proceeding described as quasi-criminal by several judgments, there is nothing wrong with the same appellation quasi-criminal being applied to a section 138 proceeding on an analysis of chapter 17 of the Negotiable Instruments Act. Another point is whether natural persons are covered by section 14. Moratorium provision contained in section 14 would apply only to the corporate debtor. The natural persons mentioned in section 141 continuing to be statutorily liable under chapter 17 of the Negotiable Instruments Act. Therefore, directors shall continue to be personally liable. So, conclusion, it was held that section 138 or 141 proceeding against a corporate debtor is covered by section 14(1)(a) of the IBC. ठीक है, तो आज की कथा यही समाप्त करते हैं.
तो इसका
हाँ
कंक्लूजन ये हुआ
हाँ
कि कंपनी पे तो 138 का कोई इम्पैक्ट नहीं आएगा, बट दे कैन गो अगेंस्ट डायरेक्टर्स.
यस, बिल्कुल ठीक है, क्योंकि वो कहता है कि कंपनी की प्रॉपर्टी को प्रोटेक्शन है ना 14 में.
राइट.
डायरेक्टर्स के केस में तो प्रोटेक्शन है नहीं, तो डायरेक्टर्स अगर क्रिमिनल लायबल है तो उनके अगेंस्ट प्रोसीडिंग चल सकती है.
ओके.
हाँ
इफ द रिकवरी टू बी डन फ्रॉम द कंपनी, वो मोरेटोरियम पीरियड के बाद कर लो, या
हाँ बिल्कुल 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 ठीक है.
और जो रेजोल्यूशन प्लान में जो उसका ट्रीटमेंट होगा उसको एक्सेप्ट करें. नहीं
हाँ बिल्कुल बिल्कुल बिल्कुल.
ओके.
Sir, just one.
कल करते हैं फिर. यस यस जान जी बोलिए.
Can I, apart from syllabus, just as a knowledge, I can guide what are the scenarios on Go Air case currently? Can we request if can update?
इसका केस कौन सा?
नहीं, Go Air केस का, यानी नॉट इन सिलेबस, मतलब ये तो जो करंटली जो Go Air का केस चल रहा है, Go Air कंपनी है, एयर कंपनी. हाँ
चलो
हाँ
मैं जरा ग्रुप में
Yes.
बता दूंगा फिर उस बारे में, मैं भी थोड़ा सा
Okay,
update
okay.
लूँ। हाँ जी, आई डिस्कस इन
बिल्कुल।
ग्रुप, ठीक है, ओके,
yeah. Okay, good day, good night.
गुड नाइट।
Good night, sir.